what law means to. I am Mwisi Mudukbe Nyim. This is the second episode we're having in our series on hire purchase, and we're glad to have you. Today, in this episode, we'll be distinguishing hire purchase from similar transactions. This is because hire purchase may appear to be similar to other transactions, but it may essentially be different from them. And those transactions may look akin to hire purchase, but they may not be the same. And so if you are under that confusion, you may run into problem. You may run into problem as a person who is looking for a mode to finance a good or a product you hope to finance. You may also run into that type of problem if you have that confusion as a law student, particularly when you encounter such questions that we call problem or scenario questions. Now, in scenario questions, when a transaction that looks similar to hire purchase but essentially lacks a characteristic that differentiates it from hire purchase is now crafted in a scenario question, and you don't really know exactly where the distinguishing lines are drawn, you may run into problem faced with that kind of question as a law student. You may even run into a problem as a counsel, or as a public administrator, or as simply someone who is faced with the responsibility of, in true life situation, distinguishing exactly what you are into or what a loved one or another person towards which you have some level of responsibility is facing. And so this is why we need to do this distinction between hire purchase and other transactions that may look so much like hire purchase but are essentially not hire purchase. I'll pause here and invite you to join our community by clicking on the subscription button, sharing to your loved ones, clicking on the like button as well, and giving us a feedback on how you view things, either on this episode or any other episode, what you would like us to be doing on this channel, how you hope that this channel will generally serve you better. Thank you very much. So, we are looking at a distinction of hire purchase from similar commercial transaction. Hire purchase actually may be confused with other transactions which bear similar characteristics. You see, even identical twins, though identical, may have features, and in fact do usually have features that distinguish one from the other. So as we can see, the word hire purchase is constructed from two words. In the last episode, when we were doing a deconstruction of the word hire purchase, we were saying that the word hire and purchase mean completely two different things. So that two transactions are even joined together to form one type of transaction shows that that unified transaction has similar or near features with either of the two that were joined together to make this unified transaction. So by simply looking at that, you now see that there is need to do a distinction. And for this, we will be looking at hire purchase and hire. That's the distinction between hire purchase and hire. We'll be looking at the distinction between hire purchase and loans. We'll do a distinction between hire purchase and mortgages. We'll do a distinction between hire purchase and sale on credit terms. Then we'll look at hire purchase and conditional sale agreement. We'll thereafter look at hire purchase and lease. Then we'll look at hire purchase and sale. So we are beginning by taking a look at hire purchase and hire. Now, you already know what hire purchase is from our first episode, so I'll be paying attention to what hire actually means. Now, hire has been defined to be a form of payment, and it has been defined as to procure the temporary use of property, usually at a set price. And you will see this definition is given by Black's Law Dictionary, edited by Brian A. Garner. I'm making use of the 7th edition actually. In other words, hire is letting out of goods for money consideration, and this is given by Falex on its free dictionary, which is available online. So these two definitions that we have looked at actually as concerns what hire is appears as though hire relates to only things, but this is not so. So these previous definitions will look like are kept making the subject matter of hire to be goods, but that is not so. Men, and I mean human beings, can equally be hired. How do you hire human beings? By hiring their services. When you hire the services of human beings, you have hired them, so to speak. So thus, this form of contract is said to be divided into two. So hire is divided into two. There are actually two things that can be hired. The first is locatio, otherwise called locatio conductio rei. What does this entail? It is the payment or the hire of a thing. When things or goods are being hired, that is locatio conductio rei. But the second is locatio operis, and that is the hire of services. I got a definition of hire that actually encapsulates these two forms of hire, that is the locatio conductio rei as well as the locatio operis. And this definition is given by Edwards I in his work A Treatise on the Law of Payment Contract, connected with the custody and possession of personal property. This book is the 2nd edition, Bank and Brothers 1879, and he defines hire as payment for hire embrace a great variety of contracts connected with and growing out of the delivery of personal property on an agreement mutually beneficial to the contracting parties. Letting for hire, or as the phrase is commonly used, letting to hire, is a payment where compensation is given for the use of a thing or for labor and services about it or upon it. The contract embraces the hire of storage, the hire of things, the hire of labor and services, and the hire of carriage or transportation. So hire is thus a transaction under which a party lets out his goods. This you will see, where is goods, you will see it on the authority of Olametan versus SFAO. You see the authority supplied on your screen. A hire is also related to property, and you will see this on the authority of Maxen and Trim Nigeria Limited versus Messrs. T. Frangi Transport and another. You will also see the authority supplied on your screen. And where it is a hire in relation to services, you will see this on the authority of Umfluf versus Bassett. The authority is also supplied on your screen. Now, all of this is usually done at a fee for a period agreed to by the parties involved to the transaction. Now, having known what a hire is, you will find that the basic difference between a hire and a hire purchase is that a hirer never intends to own the goods. But a person that engages in hire purchase transaction hopes that he will own the goods in future, even though he set out from the beginning in a hire or on hire, he hopes that he will get to a point where he will have the right of purchase, and if he does exercise, then he will now own the goods. That is the essential difference between a mere hire and a hire purchase. We'll now look at hire purchase and loans, and to enable us do that, we'll be looking at what a loan is. Knowing what a loan is will help us to know the distinction between a loan and a hire. A loan has been defined as a sum of money that one or more individuals or companies borrow from banks or other financial institutions so as to financially manage planned or unplanned events. In doing so, the borrower incurs a debt which he has to pay back with interest and within a given period of time. The recipient and the lender must agree on the terms of the loan before any money changes hands. In some cases, the lender requires the borrower to offer an asset up for collateral, which will be outlined in the loan document. Loans can be given to individuals, corporations, and governments. The main idea behind taking out one is to get funds to grow one's overall money supply. The interest and fees serve as sources of revenue for the lender. This definition is given by Corporate Finance Institute Law. That document I found online, you see it supplied. So the basic difference between a loan and a hire purchase is that the title in the subject matter of a loan agreement is never intended to revert back to the beneficiary of the loan, even though he or she might be expected to pay back the loan with interest. Again, most often than not, the subject matter of a loan you find is usually money, but the subject matter of a hire purchase agreement can actually never be money. It's always a good or a product. So sometimes what is in fact a loan agreement may be referred to as a hire purchase in the contract document by parties. But even if parties refer to a loan agreement as a hire purchase agreement, that does not essentially change that their agreement into a hire purchase agreement simply because they refer to it as hire purchase. This will not serve to make the transaction to metamorphose from a mere loan to a hire purchase, and courts have made this pronouncement in similar situation. So you will see this on the authority of Gombe State Cooperative Savings and Loans versus Guarantee Trust Bank PLC and others. It's a 2018 case. You will find the authority supplied. You also see this in Biloxi and Company Limited and another versus South Trust Bank and others. Authority also supplied. Finally, you see the case of Jajira versus Northern Brewery, and of course the case of John Allen and Co. Limited versus Sani had earlier been given. We'll now look at hire purchase and mortgage, and in similar fashion we'll begin by examining what a mortgage is, and I will take the definition of mortgages from the case of George Akonde, Nigeria Limited and another versus Enterprise Bank Limited and another. This definition was given per Ndukwe Anyanwu JCA. For him, there is in fact a distinction between a legal mortgage and an equitable mortgage. A legal mortgage transfers title in the property to the mortgagee, and the term of the mortgage may give right of sale to the mortgagee without court order. However, an equitable mortgage by way of deposit of title deed does not transfer the title in the property to the mortgagee, and the equitable mortgagee can only enforce his right of sale upon an order of court. Let's look at another case law definition of a mortgage, and this is the case of Adetono and another versus Zenith International Bank PLC. In this case, the court held that in a proper mortgage, the title to the property must have been transferred to the mortgagee subject to the provision mortgage property being reconveyed by the mortgagee to the mortgagor. Upon performing the conditions stipulated in the mortgage deed and invariably upon payment of the debt at the time so stipulated in the deed of mortgage, the mortgagor is liable to repay the loan as stipulated, otherwise the mortgage property is foreclosed. It is settled that by a legal mortgage, the mortgagee becomes the legal owner of the property, although the mortgagor may be left in actual possession or occupation of the mortgage property. But because the mortgagee is entitled to enter into possession immediately upon the execution of the mortgage, he has a right to immediate possession. End quote. Now, in other words, it is a transfer of interest in the goods from a mortgagor to mortgagee to secure a debt. A mortgage is a transfer of interest in goods from a mortgagor to a mortgagee in order to secure a debt. A mortgage is distinguished from a hire purchase in that the subject matter of a hire purchase is never a security in lieu of a loan or a lien. It's not like a lien. So in the case of a hire purchase, non-performance may actually result in the owner of the subject matter of the hire purchase to take over the good that is the subject matter of the hire purchase agreement. However, the owner of a mortgage property is the one that loses out in the event of non-performance in the case of mortgages. And I hope that you get that distinction. In the case of a hire purchase, the person that loses out is the hirer, where there is a default. But in the case of mortgages, the owner is the one that loses his property that was used as a security in order to get a loan. That's the essential difference between mortgages and hire purchase. So, hire purchase and sell on credit terms or installment sale. Hire purchase and sale on credit terms are very similar, but they are not the same. And in doing this, we will look at what essentially is sale on credit terms or installment sale. I like to say that sale on credit terms is first of all a sale, but hire purchase is not first of all a sale. It is first of all what? A hire. It is a hire that can metamorphose into a sale eventually when the hirer exercises his right of purchase. But a sale on credit terms is first of all what? A sale. It is only that sale is made on credit terms. So, hire purchase may be very similar to sale on credit terms or installment sale, because both of them are forms of consumer credit commonly used in consumer financing, yet they are not the same. In the case of a sale on credit, a contract of sale is made from the beginning. A contract of sale is made ab initio and the goods are delivered and supplied to the purchaser. Invariably, ownership or title in the goods which are the subject matter of a sale on credit transfer to the purchaser, although the purchase price is paid at a later date, usually in agreed installments or terms stipulating an agreed period of time. You will see this on the authority of Lee and Butler, and the citation is supplied. We will now look at hire purchase and conditional sale. Hire purchase and conditional sale. In the case of conditional sale also, a conditional sale is also a sale ab initio. A conditional sale agreement has been defined as a sale in which the buyer gains immediate possession but the seller retains the title until the buyer performs a condition, especially the payment of the full price. This is the definition given by Black's Law Dictionary, 7th edition, edited by Brian A. Garner. So, A conditional sale is ab initio a sale which allows the buyer to take possession of the goods in question bereft of the title in them. It's a sale. Under this sale, he takes the good, albeit bereft of the title vested therein. The title is vested still in the seller until that condition is fulfilled, and usually most often than not, the condition to be fulfilled is usually the payment of the full sum. We will now look at the difference between hire purchase and lease. Now, what is a lease? A lease has been defined by Sudhita Das in her work Hire Purchase and Lease, available online, as a contract where a party, being the owner, lessor, of an asset, a lease asset, provides the asset for use by the lessee at a consideration called rentals, either fixed or dependent on any variables, for a certain period, which is called the lease period, either fixed or flexible, with an understanding that at the end of each period, the asset subject to the embedded options of the lease will either be returned to the lessor or disposed of as per the lessor's instructions. So a lease from this is similar to a hire purchase, and largely so in that both are asset financing unions. And in both of them, a party pays and takes possession for the use of an asset whose title does not devolve in him, at least not so immediately. But this may actually be where the similarities between a hire purchase and a lease end. This may just be where their similarities actually end. In the first instance, in a lease, like a hire purchase, ownership lies with the lessor. The lease, like the hirer, has the right of the lessee, like the hirer, has the right of usage of the asset, which forms the subject matter of the contract. But unlike in hire purchase, the lessee does not have the option to purchase the lease asset at the end of the lease. Again, in the case of a lease, the value of that asset depreciation, when that asset depreciates, the implication of that is usually borne by the lessor. However, in hire purchase, the value depreciation of an asset is usually borne by the hirer and not the vendor. So, also, the rental sum in a contract of lease usually covers the cost of using the asset, whereas in relation to a hire purchase, payment installment comprise of the principal amount as well as interest for the period within which the asset is being used by the hirer. Finally, lease agreements are more frequently used for longer duration rents and for bigger assets like lands, property, and so on. On the other hand, higher period of the subject matter of a hire purchase is usually way shorter than that of a lease, and usually involves lesser assets like cars, motorcycle, motorbikes, machinery, and so on. With that, we come to the end of the distinction on hire purchase and lease agreement. So we will now then take hire purchase and sale, and that will be the end of this episode. So what essentially is the difference between a hire purchase and a sale transaction? A hire purchase we already know. We will now focus on what a sale is. A sale has been defined by section 1 sub 1 of the Sale of Goods Act as a contract whereby the seller transfers or agrees to transfer the property in goods to the buyer for a money consideration called the price. In other words, per the dictum of White CJ, when two parties amicably agree that one of them shall purchase the goods of the other, it amounts to a contract purporting that the one shall sell and the other shall buy. And this was in the case of wood versus copper Miners Company. Citation supplied. So, for a contract to be said to be one of sale, there are essentially 4 ingredients that must be present in that contract. The first is that it must be a contract between the buyer and the seller. And this is on the authority of May and Butcher Limited versus R, citation supplied. The second ingredient that must be present is that it must be a contract which the subject matter is goods. The third thing is that a contract which purpose is for the transfer of the property in goods. And this is on the authority of Rowland versus Diva, as well as Eccles versus Benetza. And these 2 citations of these authorities are available on the screen. And finally, the ingredient that must be present is that it should be a contract for which the transfer of the property in the goods is for money consideration. While a sale may appear to be similar to hire purchase, they are in no wise the same. In the first instance, a contract of sale is governed by the Sale of Goods Act, whereas a hire purchase contract is governed by the Hire Purchase Act. Again, in a sale, the buyer buys or agrees to buy certain goods from a seller at an agreed price, and we have already said this on the authority of Wood versus Copper Miners. You will also see it in section 1(1) of the Sale of Goods Act earlier given. In a hire purchase, however, the hirer takes possession of the goods with an agreed down payment, and subsequently he also makes other installment payments at agreed times to exercise the right of purchase upon the payment of the last installment. This, of course, is on the authority of Lee and Butler. The seller, on the other hand, retains the ownership in the goods and until the last installment upon the goods is paid. Now, in a contract of sale again, the ownership in the goods is transferred immediately to the buyer of the goods. This is on the authority of Rowland versus Diva, citation supplied. In a hire purchase, however, the possession of the goods is transferred while the ownership retains in the owner of the goods. Again, in a contract of sale, the buyer's position is that of the owner. However, the position of the hire purchaser in a hire purchase is akin to a bailee in the contract of a bailment. He is not the owner. His position will only change upon the last installment and where he exercises the right of purchase. So further, in a sale, the payment is usually paid as a lump sum, unlike in a hire purchase where payments are made in installment. And you also find that the consideration being the purchase price merely covers the price of goods purchased. In a hire purchase, however, the consideration takes into account the higher charges for the use of goods along with the price of the goods and other things. So, again, in a contract of sale, in the event of non-payment of the price, the seller may only take legal action against the owner but not take back the goods. You'll be taking legal action against him to get the court to order him to pay the price of the goods. He will not have and you see this on the authority of Scott versus England. You also see it on McLean versus Dunn and another, and the citation is supplied. In hire purchase, however, the vendor may exercise the right of repossession where the hire purchase defaults in payment. The buyer also cannot terminate the contract and he is bound to pay the price of the goods. The hire purchaser, however, can terminate the contract by returning the goods back, and he will not be bound to make further payments to the vendor. So when it comes to repairing also, the hire vendor has to bear the expenses of the repairs. But in a sale, once the purchaser has purchased, he takes responsibility for the repairs. In sum, the difference between sale and hire purchase has been well captured, succinctly captured in case law, and I would like us to rely on one or two of such case law, since they succinctly cover the difference between hire purchase and sale. In Joe Allen Company Limited versus Sonny Adewale and another, the court per Kingdom CJ held that the test to be applied is whether or not the party receiving the goods has the legal right to return them at his own option, and thereupon cease paying installment if he has. The agreement is an agreement to hire, with possibly an option to the hirer to purchase. If he has not, the agreement is an agreement to sell. In another case, Yakasi versus Inca Motors Nigeria Limited, citation supplied per Dan Ibekwe JSC. The court said the difference an outright sale and hire purchase agreement is that in the former, the property in the vehicle passes to the purchaser as soon as the contract is entered into, whereas in hire purchase agreement, the property in the vehicle still remains vested in the owner until payment is made. With this, we have taken the last similar transaction that we have with hire purchase, and we have therefore come to the end of this episode on distinguishing hire purchase and other similar transactions. I'll just do a rundown of all of these similar transactions that we have distinguished from hire purchase, and then we'll wrap up. In the first instance, we did a distinction between hire purchase and hire purchase and loans, hire purchase and mortgages, hire purchase and sale on credit terms, hire purchase and conditional sale, hire purchase and lease, then hire purchase and sale. Thank you very much for joining us on this channel. I remain Nwesi Modupe Unyim. We invite you to be a member of our community by subscribing to this channel. Kindly click down there on the subscribe button. It will make you automatically become a member of our community, and you have access to all of that which we do and opportunities we have available to members of the community. Also ask you to spread the word around to others who may also benefit from this channel by punching on the share button. Give us a like and give us a comment in the comment section. I'll join you there. Thank you very much. Till next time. Bye.